Okay, everyone, so let's see. The other day I filed an application for a criminal complaint against the individual who has lied and lied and lied and lied and lied about me and against me. So if this was me, on the other hand, I would have already had my arraignment and would not have been notified of it and would probably have a warrant out for my arrest. But because this is not me, they haven't even been notified of their hearing yet. Okay, so let's start off with a little bit of, First off, I'm going to try not to mention the person's name because I really don't want to get, any gray area, because any gray area they're going to try to, bring me back to court and such because, I'm going against corrupt people, The district attorney's office is a bunch of corrupt imbeciles. So let's see, the application for a criminal complaint that I filled out, one or more felonies, and it says I request a hearing with notice to the accused. This is a citizen's complaint, and I'm going after them for descriptions, tampering with evidence, which is Massachusetts General Law, Chapter 268, Section 13E, and then we got perjury, which is 268, Section 1, and then we got fraud. Okay, so let's see what we got here. I'm going to read out the complaint that I filed. And remember something. I used to be with the Springfield Park Rangers. I used to be with DYS. I used to be private. When it comes to writing complaints, I know how to write a goddamn complaint. So let's see. On Friday, April 2nd, 2021, Mr. Donnelly was first made aware that blank of blank, Ware, Massachusetts, with the date of birth of October 17th, 1981, did in fact commit the criminal offense of concealing evidence as detailed within Massachusetts General Law, Chapter 268, Section 13E, being tampering with records, documents, or other objects for use in an official proceeding. Under Section B, it clearly states the following: whoever alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the record, document, or object's integrity or availability for use in an official proceeding, whether or not the proceeding is pending at the time, shall be punished by ... double I, in parentheses, in quotes. If the official proceeding involves a violation of a criminal statute, by a fine of not more than $25,000 or by imprisonment in the state prison for not more than 10 years, or in a jail or house of corrections for not more than 2.5 years, or both. And C. The record, document, or other objects need not be admissible in evidence or free of claim of privilege. Well, the evidence here is the underwear, because the cops said skin cells could have been, found in those, which honestly, that right there would have helped me, because if they would have been turned in like the officer requested, then no skin cells would have showed up because, I didn't do anything, because the person's a liar. And yes, it is hot today. Miss Blank was contacted by Hampden County Assistant District Attorney Parsons sometime in March of 2021 and decided to go forward with a criminal complaint against Mr. Jeffrey P. Donnelly for an alleged past incident. Sergeant, now Lieutenant Nicholas Gasparini of the Munson Police Department, did in fact investigate said allegation. As part of Gasparini's official narrative, Sergeant Gasparini states the following: while speaking to Blank, I asked her about the underwear that she was wearing, as there may be DNA from skin cells, and asked if her friend would be able to bring me to her residence to retrieve. Blank declined at this time and offered to bring them down another day. I informed her that it was my belief that the item would lose evidentiary value if not secured ASAP, which, as we all know, is as soon as possible. Her friend Bethany suggested that she may want to have the underwear tested if she was looking to follow through on a lawsuit. I advise that for criminal prosecution, it could be helpful to have DNA on the underwear. Blank advised that she was unsure where the underwear currently was, and again declined to have them turned over at this point. Yeah, she never actually did turn them over either. You know? As is stated in Sergeant Gasparini's official narrative, Sergeant Gasparini makes it clear to Blank that he needs Blank's object, being her underwear, for its evidentiary value. This request was being made to Blank only a couple hours after the alleged incident. Blank had told Sergeant Gasparini that she had left the place of the alleged incident, went home, took a shower, and then went immediately to the hospital. Yet Blank first refused to allow her friend to bring the officer to Blank's home to retrieve the evidence as the officer had requested. Then Blank claims that she would bring the underwear requested object to Sergeant Gasparini on another day, even after Sergeant Gasparini made it clear to Blank the importance that he receive the object as soon as possible. Miss Blank declined and in fact never turned over the requested underwear object, nor did she turn over any clothing that from the night in question, and has made contradictory statements of what she was wearing. The DNA testing of the garment would have cleared Mr. Donnelly of any wrongdoing, as Mr. Donnelly's skin cell DNA would not have been found on Blank's undergarments, as Mr. Donnelly had not done as Miss Blank had claimed. Miss Blank intentionally refused to provide the requested object, as she was fully aware that nothing would be found and this would interfere with the lawsuit she intended to file against her employer, who not only had just removed her from shifts but was in the process of terminating her employment. In fact, Miss Blank filed a suit against said employer, falsely claiming that her shifts had been taken away from her in retaliation for filing said false allegation against Mr. Donnelly, when in fact the said shifts had been taken from Blank several weeks prior to the false allegation. Miss Blank nor her attorney included Mr. Donnelly as a defendant in said lawsuit, meaning that if what Blank had declaimed, Blank or her attorney would have included said alleged incident in Mr. Donnelly as defendants in said case. It is alleged that Blank had in fact committed the act of perjury under Massachusetts General Law, Chapter 268, Section 1. Section 1, whoever being lawfully required to depose the truth in a judicial proceeding or in a proceeding in a course of justice, willfully swears or affirms falsely in a matter material to the issue or point in question, or whoever being required by law to take an oath of affirmation willfully swears or affirms falsely in a matter relative to which such oath or affirmation is required, shall be guilty of perjury. Whoever commits perjury on the trial of indictment for a capital crime shall be punished by imprisonment in the state prison for life or for any term of years, and whoever commits perjury in any other case shall be punished by imprisonment in the state prison for not more than 20 years, or by a fine of not more than $1,000, or by imprisonment in jail for not more than 2.5 years, or by both such fine and imprisonment in jail. Miss Blank, in fact, committed several actions of perjury, from making the original false allegation against Mr. Donnelly in order to falsely grounds to sue her former employer, to claiming that her former employer had retaliated against Blank by taking her shifts away after she made an official complaint against Mr. Donnelly, when in fact Miss Blank's shifts had been taken from her weeks prior to her false allegation against Mr. Donnelly. Most recently, on April 23rd, 2021, Miss Blank signed and declared under penalty of law that the above information is true and correct on a victim's financial worksheet. And under crime-related costs, Section A, medical expenses, Miss Blank claims that she paid $1,280 for massage therapy, Jessica K. $80 times 4 per month times 4 months. Mr. Donnelly had tracked down Jessica K., who is one Jessica Blank, a licensed massage therapist and owner of Blank Therapy and Wellness Center, located in Palmer, Massachusetts. Miss Jessica K. claims to know Miss K., as they had gone to school together, but claims that she had never worked on Miss Blank. And the last time that she saw Miss Blank was when Miss Blank was working at the Magic Lantern. Also, Miss K. claims that she charges $60 an hour and not $80. This shows that Miss Blank knew that Miss K was a massage therapist, and knowing this, Miss Blank falsely claimed that Miss K was her massage therapist, expecting that no one was going to look into it. This is important because Miss Blank claims that she was provided with a small sum of money in regards to a lawsuit that she filed with the Massachusetts Commission Against Discrimination against her former employer. Miss Blank had an attorney representing her in this case against her former employer, being the Magic Lantern. And if Blank received money from her former employer for lost wages, as she makes claim, then it would only make sense that her attorney would have had her former employer reimburse her $1,280 for massages, medical if true. Wherein it appears likely that Miss Blank is claiming fake unreimbursed massages in order to commit not only perjury, but a fraud against Mr. Donnelly, as she is requesting that in her sentencing recommendation that Mr. Donnelly pay her $1,280 in order to reimburse her for massages. It must also be said that if Miss Blank had entered into an agreement with her former employer, the Magic Lantern, in order to settle out of court her alleged issue with the Magic Lantern, that there is no way that the Magic Lantern would have paid Miss Blank a settlement without requiring that she sign a non-disclosure agreement. And if this is true, then Miss Blank committed a fraud by entering into a contractual agreement with Magic Lantern by taking money to sign a non-disclosure agreement, then agreeing to be a willful victim in a made-up allegation against Mr. Donnelly when contacted by Assistant District Attorney Parsons. It is not known why Miss Blank filled out and why the District Attorney's Office provided Mr. Donnelly with Miss Blank's sentencing recommendation paperwork, seeing that Mr. Donnelly has not been found guilty of any criminal activity as of yet, thus not warranting a sentencing recommendation form needing to be filled out. Respectfully submitted, Jeffrey P. Donnelly. Okay. Remember something with what was being claimed here. It was claimed that I pivoted, bobbed, weaved, went up and under a knee-high, skin-tight skirt dress, and my finger went around, up and under around a thong into the girl's anal cavity, lifted her up 2 inches off the ground, and then I was still in the same position that everything happened, which means that an arm would have been still in her dress, but it's claimed it wasn't. And like at the same time, like there's a witness, which is an off-duty Munson police officer, Donald Emerson, who made a statement saying that he heard her yell, and then he looked up and saw a surprised look on my face. So, of course, if someone yells, you're gonna have a surprised look on your face if nothing happened. And what she claims happened, I would have been facing away from the off-duty Munson police officer, which means he wouldn't have been able to see the surprised look on my face, because obviously I was standing up and had a look of surprise on my face when she yelled at me. You know, like the problem is, hell, you know something? Like, try it. I'm 6'1", close to 6'2". She's about 5'7" or so. You know, like a knee-high, skin-tight dress. There's no possible way to actually go up and under something that low, especially being someone my height, and on top of it, having a bad knee like I have because I blew my knee out in high school. I blew my ACL out, and that requires an operation to fix, which I never had done. Which, honestly, I guess it's good I never had it done, because that right there helps to show that I can't physically move the way she claims that everything happened. The problem is, which makes more sense, is she lost a couple of her shifts a couple weeks prior. I asked her how her new job at the Mardi Gras was, only to find out afterwards that she didn't get the job that she had gone for. And she was mad because I asked her about a job that I thought she had, that she thought that she had, and you know, and then she claimed that they took her shifts because she made the complaint against me, even though the shifts had been taken a couple weeks prior. So let's see. Loses shifts, makes up story, and then claims that she lost the shifts because of the story that she made up. No, you lost your shifts weeks before that and then made it up and then tried to say that you lost the shifts because of the false allegation that you made. You know, like, but then again, it makes sense when you look at the person. The person was a severe alcoholic and a drug addict. So when you have a drug addict, severe alcoholic working in a strip club, losing their shifts as a bartender at a strip club, you know, like, she wasn't half bad looking, you know, like, she was decent looking and stuff. And realistically, when you have a drug addict in a strip club who loses bartending shifts, and, well, a lot of people don't realize, unless you've worked in a strip club, is what they do is, if you lose your shifts as a bartender and you work in a strip club and you want to make money, what you do is you end up becoming a stripper, and that's how you make your money then, and you stop being a bartender altogether. So they told her she could be a waitress like Friday nights and not a bartender. That's a huge hit to, you know, the bank account. So if you look at that, you know, it makes sense that if she was going to stay at the Lantern, she was going to be a stripper. And with a drug addiction, that's, I hate to say it, how a lot of things go. But, you know, believe me, don't believe me, like, you know, that's up to you. But if you don't believe me, try it. Try what was claimed. And then you'll see the physically impossibility of what is claimed. You know, like, the worst part about this, honestly, is, yeah, I'm suffering from a lot of stress and anxiety right now for the last 6 months because of these charges. From 5 years ago. Yeah, 5 years ago. That Sergeant Gasparini 5 years ago said that nothing, that he found that nothing happened, but then all of a sudden 88 Parsons compels him to file, and he files. You know, you gotta love that. Plus, they also deleted all the evidence too. So, and she didn't turn in evidence. But when you look at it, it's like, it's not fun. It's not fun to be facing false criminal charges. You know, like, I'm actually bringing these to light because I don't want, you know, like, I'm being railroaded, and, you know, like, this is the only way I know to even, like, you know, get anyone even see what's going on. It's not fun being in my position. Just so you guys know, if you want to donate anything, my PayPal is jpdonnelly, DONNELLY, 8@AOL.com, PayPal. My email is jpdonnelly8@AOL.com. My website is jpdonnelly8.com. If you want to buy a book, I wrote Raw Emotion and Political Repression, which can be purchased off of my website or off of my Facebook. Also, if you want to buy a painting, I'm an artist. I've been an artist for over 20 years, over 20 years now. I've been an artist, practicing artist. I did go to art school. So I'm not, like, you know, a fake artist. So if you want to buy a painting or a print or a woodblock print or whatnot, any help will do. Okay, so have a great day.